Any mentioning?
Lordship, may I have your Lordship's kind leave to mention a matter for correction of the order, your Lordship. The difficulty is, your Lordship, it's of July 2023, your Lordship's order. The thing is that the issue has been raised by the department only last week, your Lordship.
Tomorrow.
I'm grateful to your Lordship.
May I have your Lordship's kind leave to mention a matter, my lord? You have appointed a commissioner, my lord, and in that commission, my lord, there was a dispute with regard to a document. There's some clarification we are seeking. Kindly, my lord, keep it to be mentioned, my lord.
Tomorrow.
May I seek your Lordship's kind leave to mention a testamentary suit, my lord, upon notice to the other side. My lord, by an order dated 19th July, your Lordship had been pleased to appoint an advocate commissioner to record evidence of the plaintiff's witnesses, my lord. The third witness was the last witness, my lord. His cross-examination is going on, will be concluded on this Saturday, my lord.
Extension.
Extension, my lord.
Tomorrow.
Instead of tomorrow, day after tomorrow.
Day after tomorrow.
Day after.
It will be a single line order only.
Day after tomorrow, I will not be aware.
Obligation.
May I have my lord's
Yes.
kind leave? I want to file this Vakalatama in the department. Your lordship leave is I am seeking.
They can.
My lord, may I permitted to mention one matter? One matter supposed to appear in the today's list, but is not appear as per the order. So, my lord, kindly
Tomorrow's list.
tomorrow. My lord, any other October month.
Then mention on in October. Why are you mentioning it right now?
Original side, commercial division, witness section, item number 1.
My lord, I appear
Yes.
for the plaintiff, my lordship. I'm led by Mr. Das.
But the witness is being examined in chief.
Undefended.
Undefended suit witness is being examined in chief.
Partly.
Is partly done, lot two occasions, my lord. Today we would try to complete the examination. May the witness will step into the box.
Yes.
এই পর্যন্ত এইটার পাঠ হয়েছিল, ঠিক আছে? এটা 3 এক্সিকিউটেড পার্ট হয়েছিল, আর বাকি দুটো আছে এখান থেকে শুরু হবে। ফার্স্ট ঠিকটা হয়ে গেছে।
এটা হয়ে গেছে তো? এটা হয়ে গেছে।
না না,
এই দুটোই হবে তাহলে।
এই দুটো হবে। মানে এটা ঠিক আছে।
একটা 16 তো 160 তো Mr. Agarwal, I am showing you a document, copy thereof is appearing at pages.
This is supplying lac to Purulia.
No, this is the bank guarantee.
Okay.
That part is over. Pages 116 of the judge's brief of document. Can you tell what is this document about? Right, zero.
Original, you're producing original?
So this photocopy, not original.
Where is the original? That is in the bank. Ask the
117 আছে check কর।
My lord, this is photocopy of the bank guarantee extended.
Where is the original?
Original is in the bank, with the forest department.
Forest department.
Kindly see the first.
Do you have any signature in this? Known signature?
Yeah, I know this assistant manager and AGM. I was there at that time.
Who signed it?
Branch manager.
Branch manager of
State Bank of Bikaner and Jaipur. Bikaner and Jaipur.
you are acquainted with the signatures.
Are the contents of this document true and correct?
Yes, true and correct.
Original. May this document be marked as an exhibit. T. T. Exhibit S. I am showing you a document, copy whereof is appearing at pages 118 to 120 of the judge's brief of document. Can you tell what is this document about? Na 17 ta gelo. 17, 18 and 19. 170, 180, 190. Okay.
Copy.
Yes.
Are you to
Yes.
what this document is about?
This is the extension of the bank guarantee. While as per,
Is there any signature?
yes,
Who wrote this letter?
this is from State Bank of Bikaner, Jaipur, signed by branch manager and assistant general manager.
Where is the original?
Original is with the forest department,
Forest Department of
Madhya Pradesh. Or
Do you find any signature of the assistant manager and assistant general manager?
yeah, here it is authorized signatory, but this was signed by AGM. Signed by AGM and branch manager.
How do you know their signatures?
I am acquainted with the signature with the signature.
Are the contents of this document true and correct?
Yes, it is true and correct.
Where is the original of this document?
Original is with the forest department, government of MP.
May this document be also marked as an exhibit.
yes.
But I'm being led by Mr. I'm being led by Mr. Shengu to me, he takes over. এখান থেকে চলবে এত অবধি হয়ে গেছে ব্যাংক গ্যারান্টি গুলো কমপ্লিট করবো
May I start your lordship? Mr. Agarwal, I'm showing you a document, a copy whereof is appearing at page 124 of the judge's brief of document. Can you tell what is this document about?
My lord, this is letter written by us, given to conservator of forest, government of MP, Balaghat division. Balaghat division. This is regarding, they have given us short delivery of the material. So we short delivery of the bamboos which we have purchased from them. So we requested them to give us the entire purchased in NIT tender. Yes. And these bamboos were infected with borer and termite and borer. Borer. So we requested them to replace.
Mr. Agarwal, do you find any date on this document?
Is 31st December 1997.
Do you accept the statements and contents of the document true and correct?
Yes, I accept it's true and correct.
Mr. Agarwal, who has issued this document on behalf of the plaintiff?
Mr. Binod Kumar Agarwal, the then director in the company.
Are you aware of the signature of Mr. Agarwal?
Yes, I'm aware.
How do you know the signature of Mr. Agarwal?
He was director of the company.
Mr. Agarwal, is this the original letter?
No, this is photocopy.
Where is the original?
Original is lost, which we have already mentioned earlier.
Can you identify the signature of Mr. Agarwal?
Yeah, Mr. Binod Kumar Agarwal.
Kindly identify and encircle in the red pencil. May I tender your lordship this document, Your Lordship? Mr. Agarwal, I'm showing you. Mr. Agarwal, I'm showing you a document, copies whereof are appearing at pages 125 and 126 of the judge's brief of document. Can you tell what is this document about?
Mhm.
One 129. এটা কোথায় গেল? ছেড়ে দিই।
My lord, this letter was given to Conservator of Forest, Madhya Pradesh, Conservator of Forest, Forest Department MP. Of Forest, Madhya Pradesh, Forest Department. My lord, this is regarding the bamboo which we have purchased. Sorry, 27,000 notional ton we have purchased. Out of that, 8,000 we lifted. Balance material, these were either termite attacked or borer attacked. So we asked them to give us time or let them segregate it. To give us some time for lifting.
Slow, be slow.
Lifting. And requested them to get it segregated. The material which is decayed, which is rotten and decayed. Department, rather they imposed rent, ground rent and interest on us. Rent and interest on us. Now we requested them that due to this condition of the material, we are not in position to lift because we need to
Speak slowly, speak slowly.
sorry, madam. Lift the rotten material. We requested them either to segregate it or give us some time. But instead they imposed ground rent and interest. So we again, through this letter, we requested them to get it waived and give us fresh material.
Who signed it?
This is my signature.
This is a copy.
Copy.
Have you sent the original?
original,
Have you sent the original to
yeah,
them?
yeah.
How did you send that?
This is by post and even
Have you tagged the acknowledgement receipt?
it is not here, my lord.
Where is that?
So this document, your lordship, is
All right. Mark as exhibit. Signature, encircle your signature. Contents of this letter is true.
Yes, true and correct.
You are aware of this.
I am aware.
Mr. Agarwal, I'm showing you a document, a copy whereof is appearing at pages 120 to 123 of the judge's brief of document.
No, থাকতে পারে।
Can you indicate what is this
No issue. Hindi document may be there.
My lord, this is again extension of the bank guarantee which we have given to them. Because we need to get it extended.
Be slow, speak slowly. They have to take dictations.
We have given to MP Forest Department, and as per court order, honorable court order, we have to get it renewed every year. So this is extension of the bank.
Where is the original?
Original is with Forest Department, MP.
Is there any signature?
Yes, my lord.
Do you know the
Authorized signature.
signatures? Whose
I-
signatures are these?
These are branch manager and assistant general manager, State Bank of Bikaner and Jhat.
Mark it. How do you know their signatures?
I was present.
The last one.
Exhibit.
Right. 127 and 128. 127. Mr. Agarwal, I'm showing you a document, a copy whereof is appearing at pages 127 and 128. Let's share that. No. wait a minute. 130.
How many documents should you produce?
There are so documents are there. Yellow. Take half an hour time. Yellow.
Half an hour.
Yes, sir. At least kindly give me 15 minutes today, your lordship, and then if it is required, your lordship. এটা কোথায় হলো? 130, 131 পরে করবো। Mr. Agarwal, I'm showing you a document appearing at pages 130 and 131 of the judge's brief of documents. Can you indicate what is this document about?
My lord, this document is issued by Conservator of Forest, Balaghat Division, MP Forest. So this is again that the material which we have sought Whatever we have purchased. They say you have to buy this,
Slow.
you have to lift this. But our contention that when it is decayed and borer attack, that we cannot purchase. Termite and borer attack. Borer
That is,
attack.
products were defective. That's why you didn't want to take it.
It is entirely, they showed us something and they are giving something else.
All right.
Attack, decayed material. We could not buy that.
Any signature is there?
Mr.
Yes,
Can you
conservator of-
identify the signature?
Whose signature is this?
Conservator of forest.
Where is the original?
This original is lost in file, my lord, which we have already. In transit. General diary is already lost with Harris Street PS. Lost with Harris Street PS.
Whose signature is this?
Conservator of forest, Balaghat, Government of India.
Do you know that?
May I tender the resolution, Mr.
Your issue is you asked for some forest products like
Yes.
bamboo.
Yes, Your Lordship.
The supply was not proper
Supply was not proper.
and were defective.
It was affected by termite. Then after, Your Lordship, they invoked the bank guarantee, which was actually given at the time of the execution of the agreement. Now, immediately, Your Lordship, with the way wanted to, Your Lordship, invoke the bank guarantee, we came before this honorable court, filed a suit, and also filed an interlocutory application where the special officer has been appointed. The special officer has visited that place and found, Your Lordship, that particular products were affected by, Your Lordship, termite. So therefore, Your Lordship, this suit is basically for recovery of money and, Your Lordship, the loss of profit and business. That's the, Your Lordship, now, Your Lordship, the bank guarantees are there. Time to time, Your Lordship, we are extending, and we are asking for, Your Lordship, the cancellation of those particular bank guarantees. That's the, Your Lordship, entire, Your Lordship, the nature.
Goods were not of merchantable quality.
Yes, Your Lordship. And, Your Lordship, the survey, the report of the receiver, Your Lordship, that also we will, Your Lordship, exhibit, Your Lordship. We'll try.
That is to be, the
True.
receiver is to be called.
Receiver, Your Lordship, is long back, Your Lordship, has already, Your Lordship, left the profession.
All right, let it be
1998, Your
complete.
Lordship. Mr. Agarwal, I'm showing you a document, a copy whereof is appearing at page 139 of the judge's brief of documents. Can you indicate what is this document about?
My lord, this letter is given by us to the Divisional Forest Officer, Balaghat Division. Divisional Forest Officer, Balaghat MP. We have given several letters and personal interviews. Requesting Forest Department to give us material which is good in quality. Not the one which is rotten or termite proof. This is a request letter again to replace quality bamboo rather than rotten and decayed.
Who wrote this letter?
This is by me,
Are the contents true and correct?
true and correct.
Encircle.
Mr. Agarwal, I'm showing you a document appearing at pages 139. I get to 138. appearing at 139 of the judge's brief of documents. Can you tell what is this document about?
My lord, this is again one further request regarding
Your letter,
mine,
signature,
mine.
mark it.
We can start AAs, your lordship.
Z A A Z A A
AA.
A, you're right.
Hmm.
A B preceded by A. The series will restart preceded by A.
AA, BP, এমনি করে করতে পারে।
Double A, double B.
Hmm.
Okay, then double A, double B, double C.
Yes, your lordship.
That will go on.
Mr. Agarwal, I'm showing you a document, copy whereof is appearing at pages 140 and 141 of the judge's brief of documents. Can you tell what is this document about?
Your letter,
No, this is given by Chief Conservator of Forest, Madhya Pradesh.
where is the
Balaghat.
original?
Original again, my lord, we lost in transit. This is the calculation of the bamboo which we have accepted. The tax, the interest and the cost of the bamboo.
Is it legible?
Yes. Bit light.
It like, yes, okay.
And we will provide your lordship the translated copy also. That is your lordship has desired, your lordship. I'll do it at the last once it is completed.
Signature,
Forest, Conservator of Forest.
Mr. Agarwal, I'm showing you a document, a copy whereof is appearing at pages 142 and 143 of the judge's brief of documents. Kindly tell what is this document.
it's your document.
Yes, sir.
Yes, my lord. this is my
Signature?
document. It's mine. Dated, this is my document signed by me. Dated 30th October 1930. 30/10/1998. My lord, this is again that same thing. We are asking for the good bamboo rather than the rotten one.
Replacement.
Replacement, either replacement or let them forego that quantity and give us the bank guarantee and whatever.
All right.
Give us the return the bank guarantee. One thing to mention, we have requested
To the court. To the court.
we have requested Forest Department to call for a legal advice from independent authorities, whether this material is consumable or not. So, but they have not agreed.
Volunteered, not to the court, volunteered.
Consumable. For which we seek legal advice.
Is it your signature?
Are the contents true and correct?
Yes, it's true and correct.
How many documents do you have?
She may just complete it today, this with this document. On the next day, to the remaining, I'll complete it. Mr. Agarwal, I'm showing you a document. Can you tell this honorable court what is this document about?
My lord, this first page of the document is given by the special officer to our erstwhile advocate, Mr. Bajoria. The report which
So this is the copy of the report, Your Lordship, which has been sent by Your Lordship, the receiver, to the learned advocate, who was my erstwhile advocate, along with the copy of the report. So entirety, Your Lordship, it has to go.
Where is the original report?
original report is not given to us. It was given to our earlier advocate, Mr. Bajoria.
Is the original in the record?
It's not in this record, Your Lordship, because this has been passed, Your Lordship, in a interlocutory matter. We filed an interlocutory application at that point of time in 1998. Copy is checked.
Do you know any signature here?
Subhash, Mr. Subhash, the signature.
Who is Subhash?
He is special officer appointed, receiver appointed by the court.
It is his report. Is that report bears any signature of Subhash?
Yes.
Report.
Next page.
Yes, it is.
Collectively marked, encircle.
Special officer. My lord, as per court's order,
Volunteered.
they have appointed senior officer of the forest department also. So Mr. Udayan Banerjee, Mr. Udayan Banerjee is an IFS has also joined with special officer.
Indian Forest Service.
Special officer. His report is also enclosed. And I know the signature. Mr. Udayan Banerjee signature.
I know the signatures of Mr. Udayan Banerjee.
Right, circle it. Blue seal.
Originals are there in the court record?
That really also we have to check because
So
1998
before
interlocutory
producing
application.
this document, you
Yes,
check
sir.
the record.
1998 record, Your Lordship, everything has gone, Your Lordship, to the record rooms. Difficult to get that particular document, Your Lordship.
Let me see it.
And Your Lordship, we have written, Your Lordship, I should kindly see for the later we have given for production, but no steps have been taken, I believe.
All right, let me call for the record
Yes,
if it
yes.
is available.
Yes, sir.
Yes. PW1 is examined in chief in part. First up. None appeared for the defendant. for which, no, appear for the defendant. The register original site shall produce the original report of Subhash De, bar at law, dated 21st September 1998, from record if available by the returnable date. If the original is available,
Then
I will expunge it and mark the original.
Grateful, Your Lordship.
Let the suit appear in the list. When will be able to come next date?
Any,
Giving 7 days time.
Yes, sir.
4th October.
4th October, my lord. I'm not here. Can it be before 4th or after 8th?
3rd October?
Yeah.
3rd October.
Grateful.
A copy of this order may be sent to the register original site.
I'm grateful, Your Lordship. Another next day, Your Lordship will conclude it, Your Lordship.
If possible, because let the original come, or let at least some report comes,
Yes, Your Lordship.
whether the original is available or not.
Lordship. I'm grateful, Your Lordship.
Regular list to be mentioned, item number 2.
My lord, I am appearing for the plaintiff. My lord, kindly see the order of 29th August 2023. There's a minor correction in the cause title, my lord. It will be Pranay Chand Mahatab and others. The difficulty is that we are not being able to get the certified copy. देखो,
Order to the correction kar do.
it will be my lord Pranay Chand Mahatab and others.
Today is fixed for?
For correction, my lord.
Lordship, it was mentioned yesterday for correcting this order. But Your Lordship, I was praying for one more indulgence. In this suit, the issues have been submitted by the defendants. The plaintiff, I believe, has not yet filed the issues. If they file the issues, well and good. Otherwise, kindly fix a date for proceeding with the suit.
My lord,
I'm correcting it today. What about issues?
My lord, I am not briefed in this matter. I have been instructed to get the order corrected.
All right. I'm passing order necessary. A correction is needed to be made in the cause title of the order dated 29th August 2023. Full stop. The word and others within quote and others should be inserted in the cause title after the name of the defendant. Let rectification be carried out. And be uploaded in the website. Issues are yet to be framed. The learned counsel for
Lordship, for the defendant.
Filed, you have filed suggested issues.
Lordship is filed
Suggested issues. Plaintiff has not yet filed any suggested issue. Week 27 September for
Grateful, Your
considered
Lordship.
framing of issues. Either you file the suggested issue or I'll frame it.
Yes, Your Lordship.
You have filed the suggested
Yes,
issue.
my lord. I'm grateful, Your Lordship.
Grateful, Your Lordship.
Item number 3.
This is my application. 3 and 4, my lord, 2 applications in the same suit. Lord, suit
9 and 10.
9 and 10, my lord.
Who is your other side?
Lord, Mr. Mollik is appearing. My lord, in item number 4, that is IAGA 10, my lord, may I file my affidavit in reply and a supplementary affidavit, my lord, both served on my learned.
That is in 10.
10.
And so far as 9 is concerned,
9 is concerned, my lord, I tell you, lordship. This is an
My lord.
administration suit, my lord.
My lord, if your lordships allow them to file supplementary affidavit, then we have a right to file an
Very
objection.
well. I already served them.
Yes, you have
That is all
served.
right.
After time, my lord.
that is in 10.
In 10.
So far as 9 is
9
concerned,
is concerned. 9 is a
Reply has your right to file reply. That's
all
exception
right.
for substitution, my lord, which was initially allowed by this honorable court. But, my lord, it was thereafter found while, my lord, carrying out the amendment that the plaint was not traceable.
Plaint was?
Not traceable in the department. Various opportunities were given, my lord. The registrar was called upon. The parties were given liberty to come up with a copy of the
So
plaint.
plaint is, then the record is to be reconstructed.
Well, it is not possible because the plaint is, no copy of the plaint is also available. That is why, my lord, I have made an application for withdrawal of the suit. That is IAGA 10 under, my lord, the provisions of Order 23, Rule 1. That is, I am
Suit is
pressing you.
decreed.
That I'll tell you, lordship. I'll tell you. The decreed preliminary, in a preliminary form. I'll show you, lordship. But IAGA 10, my lord, is ready for hearing.
Lord, this application is not maintainable.
Very well. He will. Let me place my application, my lord.
All right.
Copies on the file for our
Affidavit in reply.
My lord, if your lordship permits him to file a supplementary affidavit, then we will file an objection to the supplementary affidavit.
Supplementary.
Did I say no?
Yes.
Supplementary.
Did I say no?
No.
My lord,
Then
supplementary.
let me pass the dictation, pass the order.
My lord, may I? Supplementary affidavit, my lord, discloses one letter.
Maybe.
Nothing else.
Supplementary affidavit is filed by you're the applicant.
Plaintiff applicant.
Plaintiff applicant in GA 10.
Yes.
GA 10. Copy served, let the same be kept in record. The learned counsel for the defendant craves leave to file affidavit in opposition against the supplementary affidavit. Leave is granted. Was there any order to reconstruct the plaint?
Yes, my lord, there was. But, my lord, the plaint was not traceable in the department. Neither is any copy available with the parties. That is why, my lord, I have come up with this application. I had made a submission, oral submission. It fell from your lordship that make an application, and I have made this application.
Let the matter appear in the list on 23rd November.
My lord, my affidavit in reply in IAGA 10 and the supplementary affidavit I have filed.
Affidavit in reply as well as supplementary affidavit be kept in record.
My lord, one more indulgence I am seeking, my lord. I am praying for your lordship.
Affidavit in opposition, তার আগে লিখে দিন, লিখে দাও। Supplementary affidavit or affidavit in reply be kept in record.
But I am praying for your lordship's indulgence to file my
Affidavit in opposition, supplementary affidavit and affidavit in reply be kept in record.
wakalatnama on behalf of some other Shebayats, my lord. I am seeking leave to file the wakalatnama.
The learned counsel also seeks leave to file wakalatnama on behalf of some other Shebayats
Who are parties, my lord.
who are parties to the suit.
Yes.
Let the same be filed in the department.
Deeply obliged.
Deeply
5 to 13.
Right, number 5 to 13. Here, Lordship has have wanted us to answer the maintainability after the Waqf Act has been. Lordship, the similar issue is pending in the other matter where Mr. Devnath Ghosh was submitting. Lordship, that is to appear on 10th October. Lordship may keep both the matters because the issues are same. Lordship may keep both the matters on the same day, 10th of October.
In Pindari Faridi's case, Supreme Court has set a guideline. Observation, these types of case will come, these types of case will not come. So one suit may succeed, one suit may not. All right, 10th October.
But
10th
there is a
October.
difference. There would be a difference. I don't know about the facts in the other case, which my learned friend is referring. But here,
Facts are immaterial. It is the issue.
Facts on
that
facts.
the
facts would be
scheme-
material.
The
Facts would be
scheme, in the same case, both the cases, scheme has
question
been
is not-
framed by the honorable court.
Question is not scheme. We have to follow that judgment.
Lordship,
Judgment has framed, because when the scheme was framed, this Walk-off Act did not came into existence.
Not at all. Not at all.
And subsequently, Walk-off Act, after coming into force of Walk-off Act, that was amended in the year 2013. After amendment, prior
Lordship,
to amendment, there was one judgment that is from Calcutta itself.
Lordship.
After amendment, another judgment that is Pindari Koridi, and another judgment was passed in 2019. The
Lordship.
scenario is different.
Whether, Lordship, those will apply in a pending suit, Lordship, that is the question.
And in such
Lordship, we
kind
shall
of
be,
cases-
in case
Maybe
where
pending suit.
already the
I
suit has
will
been
hear.
decreed by a
I will
scheme,
hear.
Lordship. Kindly keeps it on 10th October.
But I will
Hmm?
just try to, my lord, figure out what is the facts. But
Shata
here,
Sir,
my lord,
it is a-
the suit was for, the initial original suit was for management and administration, because there was some mismanagement. Here a scheme, final scheme has been framed. Thereafter, another scheme, there was a slight
All
modification.
right,
in the
there,
scheme.
let there be accepted certain facts. One fact is that schemes were framed and the whole
But today,
administration
what
is
all,
different.
today, what all applications are coming up? This is
Pursuant to
by
the scheme.
pursuant to the scheme, because it is considered that
Come on
this
the
suit
next
is the administrative suit.
All right, come on the next date.
My lord, may I make a submission, my lord? I appear for one of the applicants, my lord. I appear on VC for one of the applicants. My lord, let the Waqf board, my lord, give a short note of submission. If the notes of
They want to
submissions are
fix
there.
it, they want to fix it on 10th because other matters are also fixed on 10th.
My lord, what I request is, my lord, before this court, my lord, is that notes of, my lord, the submissions may be given. So that
Then
it
I'm
will
giving
be-
liberty the parties to file notes of argument. That would be better.
That would be better, my lord. It would be better.
Lordship can do that.
You file
can
notes
we
of
exchange
argument
it?
and also make oral submissions. Make both.
Of course, my lord, yes.
Your oral
On the basis
submission-
of the written submission.
That has to be there.
So first, lordship is
On
here
prayer
is-
of the learned counsel. Counsel for the parties. Hearing as adjourned to 10th October. Parties are at liberty to file notes of argument. In the meantime, serving copies to the other side.
My lord,
on the
even the
point of
applicants, there were a few
incredibility of-
applicants. Liberty also to the
To the part,
applicants.
to parties. It is not
Then
applicant
include-
specific, it must be party specific.
But party would then mean only the my lord, plaintiff and defendants, my lord. There are different, my lord. There are applicants also.
There are interveners, my lord. So your
Applicants,
lordship,
okay, okay.
applicants.
Parties and applicants.
Parties and applicants.
Greatly obliged.
Obligement.
Now, with
That order
But
is
it
passed. We are
restricted
hearing
to
on mental
maintain-
immunity. Yes, all matters. 10th. All right, fixing it or 10th. You file the notes of argument if you like to file it. I will hear that.
Item number 10 has got nothing to do with the maintainability. That's a KMC, which in item number 10 logic, the Waqf board is the owner of the land of belonging. to
I will hear on that
Kashmir.
date.
That's different. That has got nothing to do with.
I will hear on that date.
this touches a
Obviously.
Obligement.
Item number 14.
But my application is also suit for administration, my lord. But this suit has been disposed of. But if your lordship kindly comes to page 87 straight away of my application. Order dated 26th March 2019, my lord. His lordship, my lord, upon examination of the records,
Suit was
transpires.
disposed of on 1950, September 8,
Yes.
1952.
1952.
My lord, by
So
this-
department is directed to strike out the suit from
Yes.
the ledger forthwith.
Yes,
Lots.
but my lord, the official receiver has continued to function because there is no official, my lord, formal order of.
There is no
discharge.
formal order of discharge one. That's the reason receivers.
I'm only, my lord, seeking that order, my lord, for formal discharge of the receiver, my lord, official receiver. And my lord, handing over of certain documents, orders,
Whatever,
And colour the-
whatever documents are lying,
and my lord, the funds.
And statement of accounts.
Yes.
whatever documents are.
This court, in terms of order, this court, the coordinate bench comma, in terms of order dated 26th March 2019. Observe that the suit was disposed of on 8/9/1952. Full stop. A consequent direction was passed to the department to strike up the suit from the ledger forthwith. However, the official receiver was not discharged. Full stop. GA 11 of 23 is filed with that prayer,
But my prayers are at page 21.
along with related prayers. You are representing official receiver. Learned counsel for the official receiver is present today. Prayer. I am not allowing prayer A right now.
Subject to accounts, my lord, yes.
No, first let the accounts
Yes,
come,
yes.
then I will discharge.
Very well, very well.
Before discharge, the official receiver shall submit statement of accounts and shall hand over and or transfer the cause papers, including the original order dated 14/8/1950.
My lord, original order, I have to take instruction whether that is there.
You mentioned that in your report.
Lordship.
That is not available.
Lordship.
May not be.
Lordship.
In suit number 2727 of 1950, whereby the original receiver was appointed.
Lordship.
You try to find it out.
Lordship. If there is a record below, definitely will.
Yes, may not be. Old documents are there.
Lordship. Lordship.
Full stop. The report shall be filed on or before the returnable date.
Lordship.
Let the matter appear in the list on 24th November.
Deeply.
24.
Item 15 to 18.
I am the applicant, my lord. This is the Chatterjee International flats regarding to the Chatterjee International, my lord. These are also applicants who have agreement for sale in their favor.
Same kind of thing.
Last one.
Who is the receiver? You are the receiver.
They are the joint administrators.
Joint administrator. You
My
filed a
affidavit
report.
of service may be taken on record, my lord.
You filed a report
The report is here. Report we have prepared.
before order.
Because your lordship has already directed to file report in other matters. Madam, may I hand over a copy of the order?
No, that must be on record. Same order. Who has filed this application?
May I hand over?
The first application, my lord, item number 15, it is Mohan Impex. It's a partnership firm.
Where is the report?
Yes. Report. It's a bunch of reports.
In respect of this one?
No, all the one.
No, in respect of this particular one.
181.
GA 181. GA 181.
Who has prepared this report?
Administrators. Joint administrator.
Fill up the blank.
Blank one.
All are copy paste. You are too hasty. Making same thing for immediate order. I'm passing an order, then file on the next date, giving you 2 or 3 days time. The application GA 181 of 23 is
May I
filed.
assist your lordship to give an copy of the order?
Leave to oblige to your lordship.
by Messrs. Mohan Impex, a partnership firm represented by its partner, Sri Sujoy Khandelwal, with a prayer of the applicant to intervene in the aforesaid suit. And passing direction to the joint administrators as detailed therein. Full stop. The joint administrators are directed to submit a report on the proposed sale ascertaining any objections, if any. Report shall be filed on 27th September. What is GA 182?
182, my lord, that is also my application, my lord. This is by BK Agro Products Private Limited, a similar application, my lord.
এবার 182 তো similar order করবেন, শুধু নামটা পাল্টে যাবে।
The same thing goes for 183 and 184. Also, the applicants are different.
ওই একই অর্ডার করে দেবেন, প্রত্যেকটা আলাদা আলাদা যেহেতু চারটে আলাদা অর্ডার করে দেবেন, একই ডেট থাকবে।
Execution order দিচ্ছি
Let the matter appear, সবগুলো তো একই ডেট দিয়ে দেবেন, বা একটা লাস্ট লাইন করে দিন, all the matters shall appear in the list on 27th, অথবা 5th October করে দিন। এতগুলো চারটে ম্যাটারের লিস্ট হবে 5th October। Sign every page, do not leave anything blank. I will reject that. ঠিক আছে।
In that case, your lordship is not passing any order for execution now.
Why now?
On 5th
Let the
October.
report come,
Okay.
ascertain the objection. Why are you in so hurry?
No, no.
Let the report come, let them ascertain whether there is an objection, even of the flat owners or association, some association might be there. Then you must have ascertained that. Then come.
Very well.
Item number 19, Srimati Purovide.
My lord, item number 19, my lord, I am appearing on behalf of the plaintiffs. My lord, this is my application, my lord. My lord, in this application, my lord, I have sought for the sale of the subject immovable properties, regards which this particular partition suit was filed, my lord. My lord, the preliminary decree has been passed long back, my lord. The final report of the learned commissioner of
Have
partition
you
is
served
also.
copies of the
Commissioner
Yes,
of
my lord.
Partition, my lord, Commissioner of Partition has filed his report.
We've
I will
already,
challenge that by way of an application, which is appearing in my lord's list as item 20.
item number 22, my lord.
My lord, in that application, AOAR affidavit in opposition and affidavit in reply has been filed.
what
I was-
about your opposition or
My
statement?
lord, this is appearing for the first time, so I was humbly praying, my lord will allow me to file an opposition to this. My learned friend can
You are
file his
for?
reply. I am for the defendant number 1.
You are for?
My lord, before my lord,
And then the applications may be hard together, my lord.
before my lord passes any directions, my lord, there is one lacuna, my lord, which my application was suffering from on the last occasion, my lord, as it was pointed out by my learned friends, that the cost title had not been amended and my lord had granted us the liberty to file afresh. Now, my lord, the application which my learned friend has, my lord, which is appearing as item number 22, my lord, unfortunately, that application also suffers from the same
It was
lacuna.
filed earlier, my lord.
Because
Subsequently, amendments were
by
made.
an order dated 23rd June 2023, my lord had passed
I
an
am
order.
giving liberty to both of you to file, withdraw it and file it afresh.
No, my lord, my application has been filed afresh, but their application is not in the proper form at the
My lord,
moment.
I had filed before that.
Because They
All
had-
right, you file the application afresh.
I'll take out an application, small application for amendment, my lord. The cost title may be amended because my application was filed earlier, my lord.
My lord, for that reason, my lord, in the interregnum, my lord, my application then needs to be heard out, my lord, passes directions of affidavit.
Affidavit in
And in the meantime, they will take out an amendment application, my lord.
GA 38 is filed.
My lord, may I file the affidavit of service, my lord?
Yes. Filed by
My lord, this is plaintiff's application, my lord, 3 and 3B.
A and 3B.
Yes, my lord.
Praying for
My lord, the sale of the immovable properties.
sale
which
of
form-
the immovable properties and the incidental reliefs. The learned counsel for the defendant craves leave to file affidavit in opposition. Full stop. Affidavit in opposition is to be filed within 2 weeks. Affidavit in reply, comma, if any, within 1 week thereafter. Next.
My lord, if it commends to your lordship, can it be 3 weeks, my lord? I was humbly praying, my lord, if it commends to your lordship.
My lord, then, my lord, the matter will be after the vacation, my lord. It will be posted there from, my lord.
GA 36 of 23 is filed by defendant number 1, praying for rejection of the final report of the commissioner of the partition along with other prayers. Full stop. The learned counsel for the plaintiff craves leave to file amendment application of the cause title as, comma, during pendency of this application, cause title was changed. Cause title was amended, of the plaintiff was amended, and the same amendment are to be carried out in the application also. Leave is granted to file amendment application within 1 week with prior service of copy. Affidavit of service filed by the learned counsel for the
Plaintiffs, my lord.
plaintiffs
3A and 3B.
3A and 3B be kept in the record. The matter will appear in the list on 17th October.
My lord, that is GA 38, my lord, the
Both,
one that is
both.
both. I'm extremely grateful, my lord.
Both the applications shall be heard together. लिखे दिन? Both the applications shall appear on the list and shall be heard together.
19 and 28.
22.
19 and 22.
Item number 20.
But I am appearing on of the hairs, my lord.
This is my last order of 29th of August. 20, my lord, I have GA 25. I am the petitioner there. That's in the list. GA 25. Miller, that elected Miller non-appeared Miller for the learned receiver to submit report.
Who is the receiver? Where is the report?
Miller, he has served on us. Miller will
My
Miller.
lord, I have not received any copy.
Even I have not received, my lord.
Allow Miller to my client to file a reply to this. The
The
report.
learned receiver is present today. And
To supply a copy of the, my lord.
why do you receive the copy earlier? Why do you supply them copy without filing the same before the court? It should be, sir, placed before this court.
Your lordship order. I will search the copy. In the meantime, she connection.
Next date and submit the report. Where is that in order? Receiver shall appear personally on the next date and submit report.
That is 12 July order. Thereafter, my lord, 29th August.
Yes, it is 29th August. Nowhere it is mentioned, prior service. Nowhere it is mentioned, there will be prior service.
Excuse me.
Yeah.
Receiver is answerable to the court, not to the parties. Ki bolam? And files the report dated 9th August 23. Let the same be kept in record and copies of the report be supplied to the parties by the learned receiver, enabling them to file any exception fix 18th October, fix, no, not on October, 24th November. As returnable date. Full stop. Exceptions are to be filed in the meantime, on or before the date.
Only one humble favor.
Lord, Lord,
So far as CA 25 of 2022 is concerned, Lord, in that application, I being an occupant of a Moody property, Lord, I have asked for certain directions upon the land receiver. Lord, that application, some priority should.
All right, come on that date. I will pass. Let the report, there be exceptions against.
Well, only one clarification that yes, Miller, the land receiver has filed in the form of an affidavit, the report. Will it kindly Miller exception or reply to this? Because Miller exception in ordinance rule says.
Except exception or reply.
Yes. Exception will allow us. to
Oblique
take another-
reply. You may accept that also. May not be exception.
Malad, that is what I have exactly.
All right, that I will hear in next date.
Malad, I am asking for an adjustment of 6,50,000 plus.
All right, come on the next date. Come on the next date, I will take it up.
I've incurred out of pocket, which the landlord is liable to incur.
All right, come on the next date.
Item number 21. Manoj Roy.
My lord, I am for the petitioner in GA 13 of 2022.
My lord, directed, my lord, the learned receiver to be personally present today, while certain allegations had come against the learned receiver, he is, my lord, in derogation to the order of this honorable court, kept on, my lord, creating third-party interest one after another.
My lord, the order was passed on the 29th of August 2023.
Who is the receiver?
My lord, may I hand up first the order of the honorable court, violating which, my lord, one after another third-party interest is being created on the properties, my lord. My lord, thereafter I will substantiate with necessary documents what are the, my lord. On the second page, the relevant parties, my lord.
Now your application is that, your allegation is that the receiver violated this order dated
Yes, my lord.
18th November
My lord,
19.
yes. No, my lord, my application is of
My
my
lord,
learned friend, my lord.
yeah.
I am there, my lord.
No, my lord, I'll tell your lordship, my lord, the difficulty in this matter. My lord, my grandfather was a tenant of this property. Since 1964, my family has been there. We were the tenants in respect of the entire ground floor. being
No,
six
this
rooms.
is a separate issue. Your issue is that Umesh Kumar Pandey be accepted as a respondent.
Yes,
As
he
a
may be,
tenant, rent may be received, so and so.
no, my lord, Umesh Kumar Pandey is, my lord, a trespasser. He is somebody who had come from my village. I gave him a room in my premises to stay there because he had come from my village. Now my daughter, my lord, is a doctor. So when the COVID pandemic began, it was unsafe for my daughter to live with us because, my lord, she was exposed to a lot of COVID patients. So we requested Mr. Pandey to please leave so that the daughter then can occupy an independent room. At that point in time, we learned from Mr. Pandey that he's become a tenant. Now, this is miraculous because I have always been the tenant. And the receiver then, instead of, my lord, issuing me,
That's why the application, have you made any application against the receiver?
But we have, yes, my lord, we have separate application. May
Where is
that
that?
become, but that is not appearing, my lord. That is already pending before your lordship.
That should be heard together.
Yes, my lord. May that application, I'm providing that number, my lord. May that be.
What is the next date? What is the next date?
But this application, my lord, has not come for a long, my lord. May I? But it is GA 1782 of 2019, ACR 2214 of
GA?
1782 of 2019, in ACR 2214 of 1987.
In
ACR 2214 of 1987, my lord.
my lord, I have one prayer today, if your lordship may consider. My lord, firstly, my lord, my prayer A and C. My lord, A is, my lord, for, my lord, leave for me to intervene in the matter. Because I'm an affected party, my lord, and I'm aggrieved by an act of the officer of the court. And C, my lord, is to, my lord, allow me to make Umesh Kumar Pandey a party.
not no order right now. Let the receiver submit a report first.
My lord, receiver has, my lord, given.
There was a
My
direction.
lord,
to file a
receiver has already given very many reports, my lord, and everywhere, my lord, it is apparent, my lord. I am very much handing up one of the
Where is
reports.
your application? Without application, how are you moving
But the
this?
application is, my lord, pending, my lord. Before your lordship, my lord, the
Mention
GA
that when will it come? For hearing this application,
But,
it's very much
but the-
necessary to get a report
Yes, my lord.
Yes, my lord.
and to check
My-
whether there are any discrepancies in the report.
Yes.
This one, previous one, earlier one.
My lord, I appreciate, but my lord, already, my lord, report has been filed, my lord, and my lord,
No, my lord, there was a direction to file a report by today, as per your
That is
lordship's
another
last
matter.
order.
Because kindly have a look of the order passed by your lordship, 29th August 2023.
Yes.
The second page where it has stated
Statement of accounts, state of affairs.
affairs, yes, but the receiver shall, I will read it. The receiver
Give the
shall-
microphone to her.
Yes. The receiver shall, on the returnable date, furnish the statement of accounts as well as the state of affairs of the property, including therein the names of the occupiers and or tenants and rents payable per month, quantum of rent remaining outstanding, share of corporation taxes, if any, paid by any of the tenants, default in payment of corporation tax by any of the tenants or
Yes, I have
occupiers,
seen that.
along with the physical condition of the property. It is very much impossible for the receiver to stay what is the physical position and condition of the property. Better if a special officer,
Apart from this, file report in respect of others.
my lord, kindly.
my lord, may I submit only one? 3 properties. This is not only one property. One is at 10 Old Post Office Street, my lord. One is at Shialda Boitokhana Road. And another is, my lord, has heard the name, my lord, is famous temple in Giridih, my lord, Nalakha Mandir. That Nalakha Mandir, that also, that property, my lord, the receiver, he is the receiver in respect of. And my lord, one after
I am giving time, check all these things.
But kindly see, my lord, that the occupants, my receiver's report, the occupant of Boitokhana Road is given, and there is a fresh inductee deviating that order. But instance is before your lordship, my lord.
Report is not filed in terms of order dated 29th
My lord,
August
GA
2023.
My lord, GA 13 be served upon the receiver once again.
Your counsel is there. Why you're speaking up? Give them. Although the learned receiver is present personally through his learned counsel. Full stop. It is submitted by the learned counsel for the receiver that it is difficult for him to check the physical conditions of the property, which are differently situated, which are situated in different parts of Calcutta as well as in Giridih. Full stop. The receiver therefore shall submit report as contemplated in the order dated 29th August 23, except with the physical condition of the property. Full stop. The report shall also contain, apart from what are mentioned in the said order, the change of occupants which took place during last 5 years.
Yes.
The report will be filed on or before the returnable date before this court. The matter will be heard along with GA 13 of 22 as well as GA 1782 of 19.
2019.
Huh?
2019. 1782 of 2019.
Yes, after 2019. Let the matter appear in the list on 24th November.
And my lord, in the meantime, receiver be directed not to create any third party interest in any property in compliance to that order.
The receiver, without permission of the court, shall not change nature and character or shall not induct any new tenant or change any tenancy or whatever, or induct any person in possession.
My lord, receiver just informed me that there are 5 more premises which will be included in this G application. If
He
your lordship
is appointed receiver in respect of XYZ properties.
Exactly, my lord.
So he knows he is receiver for which properties.
And
He will submit a report
should he
including that.
state all these properties details in
Yes,
that
of
report?
course,
My
that
lord,
report
my
includes
lord,
all.
kindly read me that.
There cannot be pick and choice.
My lord, my lord. ঠিক আছে, আপনি ওটাতে লিখে দেবেন আপনার ইসে। এই তো next.
My lord is keeping it on 24th November, my lord.
Yes.
Yes. Grateful, my lord.
Any problem?
No.
Grateful, my lord.
দিয়েছে, দিয়ে দিলাম। ওরা দিয়ে দেবে আমাকে।
Item 23.
23, my lord, is my application. My lord, in the meantime, what has happened, my lord, that during pendency of this, my lord, respondent numbers 1, 2, and 6 have passed away. I have taken out
You
an
are plaintiff.
application. I am the plaintiff, my lord. Taken out an application, my lord, which is returnable before your lordship. The master summons on 27th of this month. My lord, unless that application is, my lord, taken up and, my lord, the necessary corrections are made in the cost title and substitutions are carried out.
This is GA4. GA4 is about?
GA4, my lord, GA4 of 2023.
It's
GA4
returnable.
for substitution.
Yes, it's returnable on the
It's returnable
27th.
on the 27th. my
So
lord.
let it
Why
be
it has come today?
GA4 is not perhaps, my lord.
GA4
is not appearing.
GA4 is for substitution, my lord, taken out by me.
It's returnable, my lord. on
AORC 2 of
27th.
27.
Yes, my lord.
What is the date fixed? 27 September.
27 September. my lord.
Adjourned to 27 September.
My lord, obliged, my lord.
Great.
Hopefully no AO will be there.
No, my lord, we will contest it. Because I had indicated on the last occasion, my lord, your lordship asked me to take these points when, my lord, the application appears. So I have, my lord, indicated before.
All right.
I will contest.
The only difficulty, my lord, is, my lord, I was indicated, my lord, of the death on in the month of February.
time of
Yes, some-
hearing,
That is
Yes, ma'am.
different. Yes.
Obliged, my lord.
Item 24.
My
Last-
application
the
for the
statement, my lord.
revocation
of the grant of administrative
My lord,
demonstration
prior-
on your lordship. And
My lord, prior to that, my lord, I want to show the last order which was passed. My lord, there was actually a typographical error because my lord, there was a direction for them to file an opposition. My lord, can you my lord takes the order dated September 8, 2023, my lord. Regarding GA4,
Yes.
my lord,
which one?
GA4 was taken up and my lord has directed them to my lord file an affidavit.
Let an affidavit be filed by the
Yes,
respondent
yes, my lord.
to
But
this
there-
effect.
Right.
But
Thereafter, my lord, the GA number 4 is disposed of, my lord. It cannot be disposed of because we're going to file the affidavit. It's pending, my lord. No, that, my lord, has to be, my lord, the correction is required to be there, my lord, first, my lord.
Okay. By mistake, in the order dated 8 September 23, GA4 of 23 was ordered to be disposed of.
it's not appearing in the
Since the matter is still pending, there should not be a disposal of GA4. Let the sentence within court, GA number 4 of 23, এই sentence টা দেখছেন না? এটা লিখে নেবেন, be deleted from the order dated 8 September 23. And the same be uploaded in the website.
And my lord, only another, the next line, my lord, respond should be respond, not the company, my lord. It's going to be a company, my lord, it's individuals.
In the next line, word company should also be deleted. In the penultimate line, লিখুন next now, in the penultimate line of the order, the word company should be deleted. দিয়ে এবার লিখবেন let the this be website. আচ্ছা তারপরে বাকিটা পরে বলছি।
Yes, my lord, only thing, since your lordship is passing this order, this application is not appearing in the list today, which your lordship has modified. Possibly lordship has to also treat this application as on today's list and
Yes.
then pass
Kindly
the
does
order.
that, my lord.
Otherwise, my lord, it will be
Are you
difficult.
fixing a date?
No, my lord, this application, which your lordship has right now, my lord, there is a modification which the
Order.
the correction of the order, that application is not appearing in today's list.
Yes.
So, my lord, this corrections your lordship has dictated, possibly your lordship has to treat that GA as on today's list.
Yes.
And then make the
Cannot be because GA was ordered to be disposed of. That's why it cannot come.
then this order cannot be made, my lord,
This
with the
correction is
deepest of
required to be-
respect.
It is a, my lord, the correction has to be done.
I am not saying the correction cannot be made, but there's a technical difficulty in that. If the application is disposed of and your lordship is not treating this application, first of all-
To order that GA should be then restored.
yes, but then you have to treat that application to be on day's list. Otherwise, my lord, your lordship, this order possibly.
But
is
after the correction will be done, my lord, thereafter.
No,
the-
that there cannot be any problem because the order actually it was pending. There was mistake in the record.
Right.
If I go for technicalities, then things will be delayed.
I'm not
So
saying
grateful.
technicality. It has to be, it is not, it's just one line from your lordship that is the practice in the original side, that this application has to be treated on day's list and your lordship passes that order. I'm not standing in the way. Let that
All right, this
incorporation be done.
application, when the date was fixed,
No, today was fixed. Now, my lord,
that by that earlier order, yes,
that
19 September.
earlier order, my lord,
19 September, yes.
now, my lord, in terms of that order.
All right, 19 September, today is the date fixed.
Yes, in terms of that order, I have also filed the affidavit.
May I get a copy, my lord? I have not received a
No,
copy.
copy though. But I've said that the document is not with
The
me.
J4 of 23 accordingly be treated as in today's list.
My lord, that's.
Yes,
how-
you are correct.
My lord,
Affidavit in opposition against GA number.
not opposition, my lord. Your lordship has indicated only to the extent whether this document is with me or not. Lord, not really a detailed opposition. I have filed that. May I file it?
Affidavit in opposition.
No, my lord, it's an affidavit in terms of the order.
Affidavit in terms of the order dated
8 September 2023 is put on record.
be kept in record.
Yes. And also the copy is supplied to my learned friend.
Today, my lord, a copy has been just handed over, my lord.
My lord. Now, my lord, as far as the main application is concerned, my learned friend is supposed to, my lord, argue my application.
Are you correct?
Yes, I have argued. You're supposed to, my lord, argue.
My lord,
Because this affidavit is also now with him, where I have said I don't have that document of handing over. Now,
my
he has
lord,
to
this affidavit,
advance
my lord, will turn on a lot of things because my lord, because my lord, in GA number 3, the opposition, my lord, we are specifically content that this application, why they have made this application. The reason is that, my lord, there is a part of the property, my lord, which is admittedly under the administrator. My lord, that property has been dealt.
GA4.
GA4.
GA4, my lord.
My application for his removal.
ওটাকে আনতে হবে। Keeping it tomorrow because that is shown disposed of, that has gone to the record room. So
No,
that
but now the argument is being made in respect of GA4. That is GA3. That GA3 is very much before your lordship.
both come together. Come tomorrow. I will call the records.
Okay.
Tomorrow?
And, my lord, can it be refunded after 2 weeks, my lord? Well,
No,
the reason-
This I am opposing.
Let the matter be regularized first.
This
Come
I am
tomorrow.
opposing. 3 times advocate change has
Let
happened.
the matter
Now
appear
Mr.
in the list.
Malik is here.
Let GA number
3 and GA number 4 both appear tomorrow.
GA number 3 of
3 of my lord, 2021 and
GA
GA number 4 of 2023 both.
GA number 3 of 2021 and GA number
4 of
2023
both appear.
in. Let GA number 3 and 4 so and so appear in the list tomorrow.
For hearing, my lord. That
For
was the
hearing.
last order of.
Did it come up, my lord? We'll consider it, my lord. Grateful, my lord.
It was for hearing, my lord.
My lord, this is my application.
জানি না যে দাদা করে আছে আমার জুনিয়র আপনার জুনিয়র জানি না যে আপনি প্রেজেন্ট আছে
আমি আছি দুজন আছি
Item number 25.
Yes.
Kirtan Seal.
My lord, in this matter, my lord, lordship would recall I had commenced my arguments. My lord, this is regarding sale of same property twice.
Next, you are also in the next matter.
Yes, yes. Coincidentally, 2 matters are there.
Oh.
My lord, I am leading Mr. Bhattacharya, my lord. He was not aware appearing in the virtual mode that I am there. So,
sorry, my lord.
so my lord, what
He is appearing in virtual mode. You are not virtual man.
No, my lord, I believe my junior tells me that he is with me. So, my lord, I had started my argument. It fell from your lordship, my lord. Lordship wanted to see the original deeds which were directed to be produced. Now, my lord, today it was supposed to be here. I understand there has been a mishap in my client's family, and so he has to go to Chennai. So kindly keep it anytime next week. I shall produce the originals and I shall commence the.
An accommodation is sought for. You are for?
My lord, I am for the petitioner.
On behalf of the petitioner in GA 54 of 21.
Yes.
I'm for the respondent, but no one is for the plaintiff or the defendant. এটা দারুণ কথা।
Let the matter appear in the list on
Okay,
11th October.
Lordship. 11th of October. Very grateful to you, Lordship.
Item 26.
Yes, you have finished your argument possibly.
Lord, I had opened my argument, then Mr. Devnath Ghosh has given his reply. I am to, my lord, give the rejoinder.
Sir, I'm being led by Mr. Ghosh. He's not in.
They have finished
They have
their
finished all.
My lord, lordship would recall, this was an application seeking rejection of plaint and or permanent stay of the suit on the ground that the issues involved in the suit have already been decided by an appellate court of this court. So, my lord, lordship will kindly make a note that the reliefs asked for in the application are to, my lord, rejection of plaint and or permanent stay of suit. Lordship will make that note because that is very important and I had placed it in my opening argument also. Because what transpires on this I shall show. My lord, I shall demonstrate and I'll deal with the provision of law. Kindly see the application.
Which prayer you are referring to?
Lord, if Lordship takes our application, Lordship will find page 32. Your Lordship is looking at
এটা তো প্লেন, এটা দিচ্ছ কেন application?
Let the application that should be old number is GA 2439 of 97, GA5.
Dismissal, you are praying for dismissal.
Kindly see, my lord. Civil suit 147 of 1997 and pending in this court be dismissed and or be taken off the file and or be permanently stayed. Why? The reason what I am saying is, my lord, the entire argument which has been advanced is very technical, that you can't reject a plaint. It can be dismissed either by way of a preliminary issue or it can be permanently stayed. Because I shall, my lord, the same judgments I will show. So there are threefold, my lord, all that is relevant for your lordship, because in High Court, my lord, we are not required to mention under what provision we are making it. All that, my lord, is required is that the further proceeding of the suit is vexatious because the appellate court has already decided the issue. This is the short point. Now, my lord, kindly makes a note that there are three alternative prayers: dismissal of the suit and or rejection of plaint and or permanent stay. Threefold prayers are there. Now, my lord, on facts, I will not repeat, my lord. Lordship has already taken note. Just makes a note. 167 is the order of the division bench. In this 167, kindly have a look once. I will not place it again. I am just showing the page, recapitulating the fact, and I will answer the provision of law. 167, the order starts, and specifically at page 218, this is the order of Justice Pal with Justice Jain, 22nd May 1997. And specifically at page 218,
You refer to 220.
218, 11.2.6, Lordship has seen. 218, page 218. Internal page 51.
Yes.
Sharda filed a suit in April 97 after Sushil had made an unsuccessful attempt to vacate the order appointing joint receiver so-and-so in a plaint. And this is the very same plaint and this suit, and nobody is disputing it on facts. They are also not saying this is not that plaint. In a plaint, a copy of which has been handed over to the court, Sharda has challenged the consent orders of 18th August, so-and-so, so-and-so. The consent orders have been described as a memorandum of understanding. Lordship will see the relief in the plaint, memorandum of understanding. She has also asked for perpetual injunction, so-and-so. And then, my lord, this line: the reliefs claimed are in direct conflict with the orders passed by the appellate court. And 11.3.1, whether Sharda can take a contrary stand, and my lord, that has been negated. And at page 220, 11.3.7, appellate court has held, for the reasons we uphold our order, adding Sharda as party, hold that she is bound by the consent orders passed by this court. So, my lord, there are threefold findings of the appellate court, and this is happening in a prior suit. Why I say prior suit? Because, my lord, Sharda was added as a party in appeal. And I have shown to your lordship already judgments that appeal is a continuation of a suit. So in a prior suit, Sharda is added as a party, and there is a pronouncement on the issue that Sharda cannot take a stand contrary to Sushil and is bound by that Mittal settlement or whatever is there described in this plaint as memorandum of understanding. Now, the crucial distinction factually, and this distinguishes all the judgments they have cited, appellate court order as specifically referred to this plaint in this suit and this relief.
So according to you, since
And as per order, I will make my submission on 3. The main argument which Mr. Ghosh advanced was that for barred by law, Lordship will see only 2 things. Only the plaint and what is the law effect. But I am not joining issue. I have not asked your Lordship to see anything.
if the only plaint is to be looked into, then that subsequent order cannot be looked into.
No, this is where I am on. A judge-made order is also law. I am fortified now, Millard.
No, that is true.
I have, Millard, kindly visualize, so far as my opening argument was concerned, I have not placed a single document other than the plaint and the appellate court order. Appellate court order, an order passed in appeal in this court, is also law.
Yes, definitely.
And Millard, it's a misconception to say that, Millard, a court order cannot be law. So the question is, does the appellate court order bar the suit? Answer is yes. This is my first point. Strictly going by Order 7, Rule 11. Because arguments were made, no written statement was filed. All these are being argued because they are default. Whether the issues are same or not can only be ascertained after they file the written statement. But I ask a question to myself. Am I at all required to file a written statement after the appellate? And this appellate court is binding upon all the parties, including the plaintiff. If this is not gross abuse of process, then what is? Does it lie in their mouth to come and say again that, no, you do it and I will be harassed just like this? This is the first submission. And will it kindly see at one page 220, will it kindly see the appellate court has noticed this fact. 11.3.5. There can be no doubt that Sharda has been set up by Sushil at this late stage, who, having taken full advantage of the orders passed by appeal court and enjoyed the benefits thereunder so and so, now seeks to deprive Binod of his part of benefit under orders of court. We cannot allow this. That Sharda has been set up is clear from the plaint. And it is this very plaint. And factually, my lord, there is no dispute. Neither Mr. Ghosh has argued this plaint is different. So, res judicata, whether matter is directly and substantially in issue, section 11, my lord, in all other cases, and that is the plethora of judgments, which even Mr. Ghosh has relied and he has tried to distinguish. He has said that how will the court know whether the issue is directly and substantially the same as that in the previous suit? The court will only come to know after the written statement discloses that. This is in majority cases. But in this case, court is not even required. And I have not made my argument on any, I am not required to file because the judgment which is there, judgment comes after filing of suit. But my lord, the judgment takes note of the subsequent plaint and as my lord described it in, to put it in simple words, my lord, I have shown the paragraphs. I am not making any comments myself. 3 findings. Sharda has been set up. We have perused the plaint. In the plaint, these have been described as memorandum of understanding. Well, they couch the order to give it a different shape, but essentially, and I have shown from the plaint, those are those very self-same orders which they are couching it as memorandum of understanding. And then they are saying it is not binding on me. And the appeal court says that this suit is contrary to the orders of the appeal court. And the finding is that Sharda is bound by the suit. So, my lord, my first submission is on Order 7, Rule 11. My lord, I will make 3 alternative submissions. On Order 7, Rule 11, I am not referring to anything but the plaint. My first point. I have not referred to anything else. So, I satisfy that. Lordship is not required to look into. Now, whether that plaint is barred by law, law is the judgment of 22nd May 1997, which has made a finding expressly on that very plaint. Well, this is the distinguishing feature. My lord, I have shown your lordship the appellate court called for the plaint, saw the plaint, discussed the contents of the plaint and has negated it. This sort of mischief will not do. That, my lord, this is, my lord, the languages I have shown. What is there? Sharda has been set up. The plaint has been filed. This is what they have claimed. This is contrary to appellate court's order. What the appellate court passed. What remains? And my lord, kindly see, my learned junior rightly points out 220. And this is the finding. This is law that Sharda has been set up is clear from the plaint 11.3.6. Kindly see. I forgot to place it. In fact, I had shown it on the first time. I don't know if your lordship. Kindly see 11.3.6. Lordship has found page 220.
Yes. You refer to it.
That Sharda has been set up is clear from the plaint. So, my lord, if there, and my lord, I know I am in reply, but because this argument was advanced, that don't look into the judgment. You can only look into the plaint. I am surprised. Is the judgment not law? So, my lord, to obviate that, my lord, my lord, of course, in reply, just one line, I cite this judgment, I'll give it to them if they want to distinguish.
Do one thing, both of you file notes of argument annexing your judgments.
Yes.
If a new judgment is being cited in reply, I should get a chance to.
Yes.
Both of you file notes of argument.
But this is only because I did not expect this judgment, this argument will come that our division bench judgment is not law. This is the argument advance. Don't look into the division bench judgment. Only look into the plaint. Why? Kindly see whether it is, and this is in the context of Order 7, Rule 11. Kindly have a look.
Citation.
তোকে দিয়ে দিচ্ছি ওকে একটা কপি দিয়ে দাও আমি দিয়ে দিচ্ছি 2016 SCC online Gujarat
Paragraph
8686.
Paragraph.
Yes, my lord, I'll come. My lord, kindly first come to para 27. 8686. But this I will be very candid. This is in the context of an admiralty suit. In an admiralty suit, a rejection of plaint application was taken out. Now, my lord, kindly see para 21. It is further contended, Order 7, Rule 11D states a plaint is liable to be rejected if the suit appears from the statement made in the plaint to be barred by any law. According to learned counsel for the plaintiff, law means only statute law and does not include in its ambit the law laid down by a judgment. This is exactly what they have argued. Don't look into the division bench judgment. Look only into the plaint. To look into the division bench judgment, I'll have to file a written statement. This is what I'm countering. Then Order 7, Rule 11 has been quoted in para 27. Let's straight away kindly come to Black's Law Dictionary. Straight away kindly come to para 51. I thought it was well settled, but because of the argument advanced, I am being forced to kindly come to para 50 first. After the contentions have been recorded,
law includes judicial precedents.
Yes, well, kindly come to para 49. Kindly see what was argued there. It has been vehemently argued by Mr. Bharat Rao, learned counsel for the plaintiff, that submission on behalf of the applicant that the plaint is liable to be rejected under Order 7, Rule 11D may not be accepted as Clause D of Rule 11 refers to the plaint being barred by any law. According to him, this means only the law laid down by a statute and not by the court in a judgment as a result of judicial interpretation. In this regard, reference may be made to Black's Law Dictionary, wherein the meaning of law is given as below. Law, and Millard, one of the meanings, Black's Law has many meanings given, the aggregate of legislation, judicial precedent and accepted legal principles, the body of authoritative grounds of judicial and administrative action, especially the body of rules, standards, so and so. Then para 51. In the view of this court, Law cannot be confined only to mean the enacted law contained in a statute framed by the legislature. The scope and amplitude of the word law is much wider than and takes within its sweep the binding precedent of the law, binding precedents of the Supreme Court being the highest court in the country. When one speaks to law, one refers to, when it should be speaks of law, one refers to all that is legally binding upon the courts and citizens. My lord will recall in my opening argument, I had made this argument that the division bench judgment presided by Justice Pal is binding on this court. You cannot just try the suit and say that after trial this can be negated. The word law connotes interpretation is much law laid down by judicial precedent. The word law connotes judge-made law as much as statute law. The final judicial interpretation of any provision of a statute by a court, especially apex court, or final determination of any issue arising before it is very much law. Law expounded by, and so far as this judgment of Justice Pal, it has gone all the way up. It is now binding. There is no, it has achieved its finality. So, my lord, I countered the first argument by saying that even strictly speaking, a Order 7, Rule 11 will also lie, because the plaint as it stands is barred by law, and law here means the division bench judgment of 22nd May 1997, which chronologically may come after the filing of the suit, but it is a judgment in a prior suit, because it is a judgment in appeal from a prior suit where this plaintiff was specifically added as a party. And the appellate court has noticed the mischievous nature of this plaint. And Millard has said that this plaint is contrary to the order of appeal court, and Sharda is as much bound as Sushi is. So therefore, plaint is liable to be rejected as being barred by law, the law decided by the appellate court as a precedent which is binding on your lordship. This is my first submission. And Millard, the judgment that I cited,
filed on the next date.
Yes.
Along with the notes of argument.
Millard, the second submission which was made by Mr. Ghosh, that if only the plaint is looked into, or rather section 11, res judicata, is a procedural law and not substantive law. And Order 7, Rule 11 talks of only substantive law, not procedural law. This was the submission. And my lord, he had relied on kindly takes up the judgment, my lord, I'll distinguish. Millard, he had cited, Millard, I'll just, Millard, give the principle and I'll distinguish it. 2021 9 SCC 99. Here, my lord, it was held that it can be determined only as trial of the suit, because to ascertain whether the issues are directly or substantially similar, you will have to look into the written statement. Otherwise, how will you know this issue has been decided?
Principle is very settled. While deciding on Order 7, Rule 11, written statement is not to be looked into.
Correct.
Even at the time of issuing summon, that can be considered. Court can consider itself. So that is a separate issue.
So, my lord,
It is
here
not connected
also, lordship will consider, when making my argument, I did not invite your lordship to look into anything else other than the plaint. And as far as barred by law, the only law I had cited was the judgment of our appellate court. That's all. And because it was contended that whether this judgment is binding, it is no longer, it is now, and this very plaint. And so far as this is concerned, it is not their case that this is not the same plaint, it's another plaint. Then, my lord, obviously.
Your submission is that by filing this suit, this court is invited to scrutinize, or rather to sit in the appeal of the appellate court's order.
Which plaint has already been scrutinized by the appellate court. This is the self-same plaint which has already been scrutinized by the appellate court.
That means this court will see it as an appeal of the division bench.
My lord, whether
That is barred by law.
yeah, my lord, I am saying not, my lord, not that this court is sitting in appeal. I am only saying that, my lord, the very
No, when I will consider this prayer,
correct,
that order is not binding, I have to do that, exercise that function.
correct. That order is not binding means that order has already decided that this plaint, the comments are there. Sushila has been set up, the plaint has been filed claiming this, and this is the self-same plaint. So this has already been decided.
That's why it is barred.
That is why it is barred. And for this, I have not taken your lordship to the written statement. This is my
No,
first.
that should not be.
Correct. I have not filed it. And my lord, I have also shown that the last line of the judgment, page 220, is bound by the consent orders of this court. Sushila is bound by the consent orders of this. Sharda is bound by the consent of this. So, if there is a finding to this effect made in relation to the self-same plaint, if the plaint would not have been noticed by the appellate court, this judgment of 2021 is good. That I would have to put in my written statement, look, before the appellate court, these were the issues. Therefore, section 11 and court can do it. But that very self-same plaint was noticed by the appellate court. The mischief was noted and recorded by the appellate court. The relief spread was noted and recorded by the appellate court. The contention of the plaintiff was negated by the appellate court with the finding that no, the stand in the plaint is contrary to the suit and Sharda is bound by it. And that is law. That is law so far as the parties are concerned. That is law so far as your lordships are concerned. And that will be the law for all times to come, whoever may come as either on this side or that side. This is the law.
All right. Come on the next day with the notes of argument.
Only just two short points I'll quickly answer. The other point argued was, my lord, and my lord, I have already shown this went up to the Supreme Court 282. The lordship will see the special leave petition was dismissed, the division bench judgment. So, my lord, it is now settled. And my lord, this judgment, so far as 2021 9 SCC is concerned, the lordship will see. Here, my lord, kindly comes to just one. I just distinguished this. Here also, my lord, the court is noticing, my lord, that ITC judgment. It is possible in a cleverly drafted plaint. Now, kindly come to page 110. This is 2021 9 SCC 99.
Yes.
Hanumandas Tatola. Kindly come to page 110. Para 22.
Soumitra Kumar Sen.
Yes, last 4 lines of para 22. One has to look only into the plaint for the purpose.
That is settled principle.
Yes, then, my lord, it is possible in a cleverly drafted plaint, the plaintiff has not given the details about suit number 268, which has been decided against him. He has totally omitted to mention suit number so-and-so, the judgment wherein has attained finality. In that sense, the plaintiff respondent may be guilty of suppression and concealment if the averments made by the appellant are ultimately found to be correct. However, as per established principles of law, such a defense projected in the written statement cannot be looked into while deciding application because it was projected in the written statement. Here, my lord, I don't have to refer to the written statement because the appellate court has already noted her plaint and has made the observation. And then, my lord, kindly see, Soumitra Sen has been quoted at para 23, the italics portion. My lord, italics portion is very important. And this was what was relied upon also by Mr. Ghosh. That over here also, if your lordship is finding any difficulty, whether lordship dismisses the suit as a preliminary issue also. No, kindly see what it is saying. In a case like this, Though recourse to order 7, rule 11 by the appellant was not appropriate, at the same time, the trial court may, after framing issues, take up the issues which pertain to maintainability of the suit and decide the same in the first instance. In this manner, the appellant, or for that matter, the parties, can be absolved of unnecessary agony of prolonged proceedings in case the appellant is ultimately found to be correct. But my lord, I am submitting here preliminary issue also not required because it is law already. I succeed on, my lord, order 7, rule 11 simpliciter because it's a law made by the judge.
All right. Heard Mr. Chaudhary, the learned counsel for the defendant number 5 to 9.
Yes, ma'am.
5 to 9. Both the counsels are at liberty to file notes of argument on or before the returnable date with prior service of copy. The matter will appear in the list on October 3rd.
Lordship would kindly give us not 5 minutes time on that date to consider the new judgment. That's the only point we'll cover.
He did
Include in the notes of
my lord, I
argument.
have given.
To include in the notes of argument.
Lordship knows me that one opportunity of 5 minutes. My senior will come and argue only on the judgment. That's all.
Next.
Grateful.
Item 27 and 28. Pradut Kumar Saha.
Is it originating summons, driver?
That one. Rule of perpetuity.
Yes.
Mr. Ganguly, have you any matter? Second half, I am not sure of. Second half, I have revision bench. So if I cannot finish, I won't come. So better I will adjourn all the second half matters, come tomorrow.
Finding in any court what is learning.
You may sit here.
On the last occasion, I was placing before your lordship chapter 13, the originating summons, different provisions of the rules and the scope of the rules, rule 1, rule 2, etc. What is the scope of chapter 13 of the rules? There was a direction, Milord, for giving for compilation.
My lord was pleased to ask your officers to look for it because it had been given earlier.
Yeah.
The compilation.
এইটা নিয়ে নাও, এটাকে খুলো না, হাত দিও না।
একটু পেজগুলো একটু বলে এটাকে
প্রিন্টার হাত দিও না, বুঝেছো? এটা দিও। Yes.
ঠিক আছে, আমি একটা কথা বলি ভাই, আমাকে ওরকম একটা দিয়েছে because I have prepared on the basis of these papers, Milord, pagination, my learning.
Pagination is not correct.
No. But I shall read it from my own brief. He will give the pagination of the compilation.
Yes.
কোথায় আছে? কি করছে বললে? ট্রানজিট আছে? ট্রানজিট আছে, দেখো ট্রানজিট গুলো আছে, পুরো জিট গুলো আছে, ট্রানজিট এগুলো আছে কি দেখেন না ভাই। এদিক ওদিক করলে জটে অসুবিধা হবে না।
Or you check it up, come on another day.
বলবেন কি করে বলো, আমি বলে যাচ্ছি ভাই আমার থেকে। Let us start for a day so that it can be organized. Kindly take the
originating summons first. Let us start first. Then we shall come to the difficulties later on. Please help me regarding the page of the compilation. Charge দরকার নেই, originating summons for.
Page 5, starts from page 5.
Fine.
Is it page 5 in your compilation?
Yes. Kindly take the origin. I'm reading from my brief, so we get it. Now, kindly take in short that originating summons, it is originated by the summons and the supporting affidavit is at page 2, internal page 2. Paragraph 1 gives the genealogical table. In short, Millard, I am first of all giving you the entire Millard scenario of their case. Now, what the plaintiff here says, kindly come to paragraph 2. Until September 1955, my father, Karuna Mohan Shaw, was the sole and absolute owner of premises number such and such and such and such. Kindly look at the genealogical table. Karuna, according to the plaintiff, was the sole and absolute owner of these properties.
Gopeshwar Shah had 3 sons.
3 sons. Karuna,
Shoilendra
Shoilendra
and Yudhishthir.
Now, this plaintiff Pradut, kindly come to the cause title. Pradut is the son of Karuna, first bunch. Then paragraph 3, on 20th September 1955.
Then defendant number 2 to 6
are
other sons of Karuna.
Are Shoilendra's son is Somen onwards.
No, they must be defendant number 2 to 6 must be sons of Karuna as per this.
No,
go with this.
Karuna is Karuna's Millard next generation is Pradut onwards up to Kalpana.
It is next generation of Pradut.
Karuna.
So Karuna had, I think, 1, 2, 3, 4, 5, 6
Yes.
sons and daughters.
Shoilendra is no more. He has no heir.
Right.
The bachelor. Yudhishthir
had 1 son, defendant number 1.
Defendant number 1. Except
And all other defendants are sons and daughters of Karuna. So Karuna had plaintiff and defendant number 2 to 6.
2 to 6.
1 from Yudhishthir.
Now on paragraph 3, by indenture dated 20th September 1955, Karuna Mohan Shaw purported to settle the said property on trust primarily for his own benefit and for the benefit of his two brothers, Shoilendra and Yudhishthir. I'm only giving the short names, both since this is other material provisions, etc. So Karuna, who was the owner, he became the settler and he formed the trust. Who are the beneficiaries? Karuna, Shoilendra and Yudhishthir. I shall go into the detail from the trust deed. And the provision of the trust deeds are set out. I shall go straight to the trust deed. Kindly come to paragraph 4. Page, internal page 4. By the said trust, my father Karuna appointed himself as the sole first trustee of the said trust. Other provision of appointment of future trustees and other duties, powers So far as material of the originating summons may briefly be set out here. That I shall read out from the trustee. Then 5, para 5. The said indenture contain elaborate provisions defining the powers and limitation of the trustees since they are not relevant, etc., etc. Trustees is annexed, paragraph 6, annexure A. Now, so to form a trust property is needed, that is defined. Settler is needed, the owner is the settler. He himself became the first trustee. Number 3, beneficiaries was he himself and the 2 brothers and the persons mentioned in the trust deed. And 5th, the purpose that is mentioned in the trust. 5 things are necessary to form a trust. And of course, the registration part of it. Immovable property is there. Now, paragraph 8. On 8 June 1971, Yudhishthir died. Yudhishthir means my father, defendant number 1's father died. So, defendant number 1 is his only son. Then, Karuna's widow, para 9. So, Karuna was widower. He died on 24 November 1979. And Karuna was survived by the plaintiff, his 2 brothers, whose names are appearing in the genealogical table and defendant number 2 to 6. Then paragraph 10. Shoilendra died, a bachelor, on 31st July 1982, leaving a will bequeathing all his properties to his son, to the son of the plaintiff, SUGATO Shaw. Then 11. During the lifetime of my grandfather, Gopeshwar Mohan Shaw, 3 branches of the family enjoyed the said premises according to their personal requirements on a mutually acceptable basis as determined by my grandfather under clause 2 of the said indenture. This is very important. Clause 2 I shall place before you, your lordship. Since the death of my youngest uncle, Shoilendra Mohan, I had been and still am the sole trustee of the said trust, being appointed on 31st July 1982 in terms of the said deed of trust. So, this becomes very important. Like in many other cases, to get any relief, one must be, a few things are necessary. Must be the right person. He must come to the right forum at the right time for the right relief. In whatever way your lordship looks at it, these 4 ingredients are necessary in any list. So, pausing here for a moment, in 1955, the trust was created. Settler was the father of the plaintiff. Original trustee was the father of the plaintiff. So the father of the plaintiff did not raise any objection as settler, as trustee, as one of the beneficiaries to any of the terms of the deed of trust. This is very important because your lordship is deciding and originating summons. Scope is very limited. In 1982, paragraph 12, plaintiff became the trustee. This originating summons was filed in 1999 after 16 years. any civil suit for any cause of action would have been barred by law. Any application, either declaration 58, cancellation 59, Article 58, Article 59, any application, Article 137 under any act.
But so far as Section 17 of Limitation Act, Section 17 of Limitation Act related to trust.
Against the?
Section 17 of the
against the trust.
Yes.
He is not filing anything against the trust. He is the trustee. He is the trustee. Trustee is asking for a declaration against himself. No. I am grateful, my lord. Whenever we say, think about trust, Section 10, Section 9 comes first, Limitation Act. One, you have fired the bullet, it goes. Section 9, once the limitation starts, it starts, you can't stop it. Exception, Section 10, Section 17, limited the Trust Act. Against whom? Against the trustee. But if the trustee files a case, not against himself, not against other trustees, but for a declaration, that you don't have the beneficial interest. Then, after 16 years, then he must show some cause of action. Is it such a case which has to be decided in an originating summons? More so, can it be decided in a civil suit also? Let us see what are the prayers in the originating summons. Kindly come to question framed in paragraph 24 of this affidavit. One A, whether the trust created by the indenture dated 28th September 1955 is bad. Page should be internal page 9. Page 13. Running page 13 should be. Paragraph 24 of the affidavit.
Whether the trust created
by the indenture dated 28th September 1955 is bad and honest, being hid by rule against perpetuity by reason of the provision contained in
property, rule against property.
Huh?
Rule against property.
No, by rule against perpetuity.
Property, it is written as property.
Oh. By reason of provisions of containing clause 19 of the indenture to the effect that the beneficial interest so and so. Many things we'll have to consider. Firstly, the original settler has not asked for cancellation. You are asking for declaration plus cancellation. Article 59, your lordship knows, when you for the first time come to know, limitation act. Yes. Article 58 and 59. Very interesting, Miller.
3 years from the facts. 59 is 3 years.
58 first. Any declaration?
3 years. From the right
and the right to sue first accrues. Not right to sue accrues. First accrues. At least for him in 1982. Then 59 to cancel. or set aside an instrument. 3 years when the facts entitling the plaintiff to have the instrument cancelled or set aside, etc., first become known to him. Paragraph 12, kindly have a look at. I have become wiser because of this. Undo.
So date is attributable from that one. And
First
limitations
of all,
are
I
from that
say
one.
he knew from the very beginning because his father was the settler. And his father was the sole trustee. And his father was one of the beneficiaries. He should not be allowed to say that I did not know of the trust deed or provisions thereof. It is unbelievable. Let us give him the credit. At least from 1982, he knew. So he had the first knowledge in 1982.
And this is instituted in the year 99.
Right. Something happened. I became wiser. There are some pleadings. He's trying to make out that case. I shall come to that. Law doesn't allow that. I have come to this honorable court under chapter 13, originating summons. That won't save you. Limitation is ruthless.
So your first point is limitation.
Yes. What you cannot get directly, you should not get indirectly. Right time is the one of the ingredients out of the 4. And section 3 is there. I need not trouble you a lot of the Limitation Act. Section 3 of the Limitation Act. Court should take into consideration. One cannot say that you have not taken this point. It's a duty of the court.
Irrespective of defense.
Yes, sir. Why I say so? What is the meaning of answering in positive? Question number 1A is amounts to a decree. Kindly keep this page open. Kindly take Rule 20 worker. Chapter 13, Rule 20. Achha, boy. Rule 20.
As a decree of the court.
So it will be the force of a decree of a court if it is answered in positive. So you are getting in a circuitous way. You are asking for a decree of a court after 18 years from the year you have become trustee. And I do not say you first knew or first came to know. I say you became trustee in 82 according to you. Next. He is claiming as a trustee under his father. His father has never challenged. He has enjoyed, his father has enjoyed the benefit as beneficiary. He has enjoyed the benefits under the trust as one of the beneficiaries, at least for 18 years. Then one fine morning, he thought that it is bad in law. I say, is he the right person to challenge? Is he entitled in law to challenge? After you have taken advantage of the provision of the trust deed, you can't take the advantage of the provision of the trust deed and then say it is bad. The entire trust deed is bad. It says that bad and honest. It does not say Rule 19 is bad. Sorry, Clause 19 is bad. May I read question 1A? Whether the trust created by the indenture dated 20th September 1955 is bad and honest, being hid by rule against perpetuity, by reason of the provisions contained in clause 19 of the indenture to the effect that the beneficial interest shall be perpetual in succession only to the male successor. I could understand rule clause 19 is bad. Possibly that could have been an arguable case. He says it is good, it is existing from 1955. Kindly remind this is before 1956 Act, Succession Act, etc.
Yes. Dayabhaga, it is guided by Dayabhaga.
Dayabhaga. So Rule 19 was made to avoid the female succession in beneficial interest. I shall place before Lordship Rule 2, the Clause 2 and Clause 19. If there is inconsistency, remove Clause 19. If at all there is inconsistency, can you say that the entire trust deed is bad? Now let us go straight to the trust deed now. Going to before the other thing, কোথায় ট্রাস্ট ডিডটা পড়া যাচ্ছে কোথায় বলো? কত পাতায় পড়তে পারবেন জজ সাহেব বল? তাহলে কি করে জজ সাহেব পড়বেন? কোথায় পড়তে পারবে বলো? টাইপ করা কোথায় আছে বলো? কোথায় বলো সেটা জজ সাহেব কত পাতায় জজ সাহেব বলো না? কিভাবে উনি দেখবেন বলো? আমি পড়তে পারছিলাম না বলে এখানে শুনে তাহলে কি করে পড়বেন? না টাইপ করা আছে, আবার একটা কম্পাইলেশন। ওটা খুলে নাও, তোমার ব্যাকশিটটা খুলে নাও। আজকে মুড এসে গেছে আমার, এটা বলে দিই পরের দিন দিও। দাও দুটো ক্লজ দেখি ছেড়ে দাও না আজকে। Otherwise the flow will be lost. Two clauses are important, I shall Miller, to keep the continuity. এটা টাইপ করে আনো। 20 kindly note 3 days, 20th September 1955 is the date. Date of the trust deed. Kindly come straight away to, for today, clause 2. The names of the beneficiaries are appearing in clause 1. Koruna Mohan Shaw, Shailendra Mohan Shaw, Yudhishthir Mohan Shaw.
Three sons.
Three sons. I should say three brothers. Three brothers. Koruna, Shailendra, Yudhishthir.
Three sons of the settler.
Settler is Corona.
Oh, okay, okay.
Well, so three brothers who are the three beneficiaries are Coruna, Shoilendra, Yudhishthir.
Settler-
Coruna is the settler and trustee.
Beneficiaries are three brothers.
Three brothers. Coruna is the settler come trustee, first trustee. Then two is very important. All the beneficiaries with their respective families as mentioned in clause 1 and Sri Gopeshwar Shah, father of all the three beneficiaries, shall have the right of residence as they may require for their personal occupation, and such requirement for their personal occupation shall be determined by Sri Gopeshwar Shah and any other portion of the said premises or of the trust property that may be left after such occupation shall be let out to such tenant or tenants on monthly tenancy as may be leased out for a period not exceeding 16 years on such condition or conditions as the trustees may think fit or proper, and in case of disagreement between the beneficiaries, including the trustee himself, as the portion or spaces to be occupied for the beneficiaries' respective personal occupation, such dispute shall be settled by Gopeshwar Shah, and his decision shall be binding and final on all the beneficiaries. What is important? Three brothers and the father will be the beneficiaries, and their respective families will be in occupation of those properties. Beneficial interest means they will be entitled to reside there.
And the trustee, only sole trustee would be the eldest son.
And his son.
Succession.
Now, their objection is regarding Rule 19. Clause 19. Kindly come straight to Clause 19.
Beneficial interest shall be in perpetual succession. Only to
Beneficial interest shall be perpetual in succession only to the male successor. Neglect this, omit this. It will be to the original brothers and their family members. The female members will be included. How can the trust deed go? Object of the trust does not go. He wants to demolish the trust by way of making an application under Chapter 13. A trustee is trying to demolish the trust. Incidentally, the settlers and the original trustee is his father. And kindly take clause 16 here.
Clause 16.
Yes. No.
Trustee may, without instituting
any suit, apply by a petition to the principal civil court of original jurisdiction for its opinion, advice, or direction on any prudent question.
Space for order 13 application, chapter 13 application.
Yes. Regarding respecting the management or administration of the trust property, other than the question, detail, difficulty, or importance, not proper in the opinion for the court for summary disposal. Where is the destruction or bringing an end to the trust? So he is acting contrary to clause 16 of the trust deed by making this application.
So according to you, this clause 16, makes a space for coming to this court under chapter 13. But this application is not in terms of chapter 13, nor in terms of
clause 16.
Clause 16.
I say that even if, for the sake of argument, even if there is some chance of making any application against any of the beneficiary. That is restricted by this. Because the trustee should act in terms of the trust deed.
So this is contrary to the terms of the indenture, according to you.
Well,
All right, I will hear you next on the other day. Give a
Okay.
copy of the translation.
Yes, ma'am.
I'll make a photocopy. I'll make a. Give us a
Look, I mean,
copy of
type
this.
copy.
All right.
যা করবে ভাই একরকম করো কবে করবে বলো তারপরে যাও
My lord will.
Hard in part. Adjourn to
কবে করবে এক সপ্তাহে করে দেবে
হ্যাঁ
আফটার 1 উইক এনি যা
5 তারিখটা রাখবেন তারিখ ছাড়া যে
সরকারি করো কি বলবো
except 5.
exact 5 minutes.
আফটার
6th October.
6th October. 6th October is in the morning, man.
Yes.
Yes. 6th October.
কি বার করছো
শুক্রবার শুক্রবার সকালেই যাবো
I am not burdening your afternoon.
No, no. In the morning. I'm like 6th October. I'm like
Yes, sir.
my Mr. Bhattacharya wants to make some submission with regard to the papers. Kindly hear him. Dedication.
Use microphone.
It was filled from your lordship on last occasion. About the numbering of this case. That it should have been instead of matter number or the originating summons suit number, CSOS number. And when the original side rules was amended on in 2008.
That is easy to.
And at the relevant time when the matter was filed, it was used to be numbered as originating summons suit.
Yes.
বলে দিয়েছি তো বলে দিয়েছি তো হ্যাঁ
Only this notification is there, my lord, in clause 2, the notification is there. That's what.
What is with name? What is with name?
There's nothing in there.
What's in a name?
Great.
All right.
I was a little bit.
29. It will take
Item
time.
29.
29, my lord, I would be praying for an accommodation.
Yes, you have to be.
My lord will kindly give me an accommodation for the week, my lord, and kindly keeps it on Monday. Mr. Shornendu Ghosh, who was arguing before my lord, he is, my lord, suffering from fever, my lord. So he's requested me to pray for an adjournment for the week.
Because it's a prolonged argument.
My
It
lord.
needs time.
My lord.
Time to hear. Whether it's originating someone's suit or not.
Or not, my lord.
Because you have alleged they have breach of trust. They have alleged you have breach of trust. You have committed breach of trust.
Yes.
Whether that can be considered in OS.
My lord.
Adjourn on prayer of the learned counsel
For the plaintiffs.
for the plaintiffs. Hearing is adjourned to, further hearing is adjourned to 4th October.
4th October. I'm grateful to my lord.
Item 30.
But item 30, my lord, is appearing as my instance, the plaintiff. Lord, she will kindly take my lord's last two orders. One of the 12th of June, 2023. I have a copy of it. Sure. 12th June order, amendments were allowed. 12th June order, the amendments were allowed by my lord. Order in terms of period A to T of the master summons was the amendment to the petition in a partition suit. Now the difficulty was the records were not available in the department, lost, but not traced, not next order, 24th of July. My lord has asked the department to once again to trace out the records.
Report.
No, there is found, is traceable. We have got the records. So lordship will kindly extend the time for us to carry out the amendment in terms of the order of 12th of June. That is the only thing required.
The learned counsel for the councils.
Yes. I'm for the defendant in this matter.
Both of you submit.
No,
It's a defendant.
I'm for the
Learned counsel submit that for the party, submit that record could be traced, has been traced.
Has been.
And the department is in process of carrying out amendments. An accommodation is prayed for to finish the job of amendments.
2 weeks from it.
Accordingly, time is extended till 11th October.
11th October. Obliged, deeply obliged.
Item 31 and 32, but I'm appearing on behalf of the defendant number 128.
My lord, item number 31 and 32, there was a direction to file a report by the special officer, my lord.
What is the special officer?
Defendant numbers 10 to
last
12,
officer-
my lord.
This is my report, my lord.
You are special officer. The joint special officers.
Let maybe get a copy of the report, my lord.
My lord, there was no direction to serve the copy of the.
Definitely, you are not supposed to serve. You are not supposed to serve it
Yes.
previously to them. This is to be submitted before this court. If the court orders,
Yes.
then you can be served. The report of the joint special officers, 2 reports are filed by the special officers appointed by this court. A copy of the report, the reports may be kept in record and copies may be handed over to the parties for filing replies / exceptions. Fix 29th November for filing
দিয়ে দিচ্ছে আমার কাছে এখন copy
reply / exceptions.
copy নেই দিয়ে দিচ্ছে
I'm sorry, my lord, I missed your lordship as my lord recorded in the order that my lord a copy has been served or should be served.
Should be served.
Should
Let a
be
copy be served. Let copies be served upon the parties.
Yes, my lord. My lord, hard copy, my lord, yes.
Handing over right.
Thank you so much.
My lord, hard copy should be served, my lord. Well, he's submitting for your lordship, he has sent through mail,
I
but
have
when he's,
hard copy right.
he's not with me.
I won't direct what it would be a manner of service, because even a soft copy is served, that is also good service.
But when this is a printout, my lord, it's a.
That is up to you. Why should not you take a printout, your own printout?
If it is printout, my lord, but it is coming as a black, my lord. That is why I'm saying.
That's the problem of with your machine. She is not to be blamed. Yes.
Lordship, my lord, may I just one my lord, humble request, my lord. The GS6, my lord, I have seen, my lord, an order dated 15th of May 2023, my lord, which records, my lord, filing of 2 GAs, my lord, 6 and 7, my lord. But if a copy of GS7 be served upon me, my lord, because GS6, my lord, I'll tell you the reason why, my lord. We are appearing for the first time on behalf of 10 to 12, my lord. Earlier, my lord, 1 to 12 was.
GS7?
Yes, my lord.
You are for?
I'm for 10 to 12, my lord. I need a copy of.
I think instead of wasting time, they can write us later.
But now that I already informed him, my lord.
The learned counsel appearing for defendant number
10 to 12, my lord.
10 to 12 submits that copy of GA
6.
6 of
6 of 2021.
2021 be served upon them. The plaintiff, it's plaintiff's application. Plaintiff is to serve copy of the application to the answering defendants immediately.
Great.
Keep you. Matter will be appear on, my lord.
May I?
29.
Fix the date, 29 November.
May I just seek one indulgence, my lord, for inclusion of a restoration application, my lord.
Come tomorrow.
I'll just.